very excited to be featured in Fact this year, and with this video, we'd like to share with you some reflections from our position paper about one of the biggest legal reforms in the European Union for the years to come, namely the Digital Services Act. I'm Catalina Goanta, Associate Professor at Utrecht University, and my co-authors are Thales Bertaglia, PhD researcher at Maastricht University, and Iamnitchi, Professor at Maastricht University. We joined forces to bring together our expertise in law and respectively computer science to tackle the spiky topic of digital enforcement and access to platform data when dealing with protecting a vulnerable category of social media users, children. This video has 3 parts. First, I'll tell you how content creators have become professional users and what that entails for child content creators. Second, I'll make an overview of a few essential points that you should remember about the Digital Services Act. And lastly, I'll discuss our proposed legal compliance API. It's highly likely that you've seen at least one news headline this year about content creators, or the other names they go by, depending on what platforms they use, what business models they engage in, what part of the world they come from, and so on and so forth. Earlier identified as influencers, content creators have become known for their famous but also infamous successes around influencer marketing as an advertising business model, as can be seen in the 2017 Fire Festival conundrum. If you're interested in that, there's quite a few documentaries on this scandal. By 2020, social media analytics companies were reporting tens of millions of amateur, but also professional content creators around the world. While scientifically rigorous numbers are very hard to come by, and remember this issue for later, what such market research reports make clear is that the content creator economy has evolved in various iterations or phases. When platforms such as Facebook were all about social graphs and sharing funny, homemade cat videos, we used to speak about user-generated content. At that time, monetization opportunities were scarce, as social media platforms were themselves experimenting with business models around advertising and data collection. Facilitated by the internet presence of offline celebrities and increasingly more native internet celebrities, the narrative around content creators shifted towards influencer marketing. Celebrities, increasingly referred to as influencers, started capturing attention, converting impressions or engagement into sales through the use of affiliate marketing, barter, or endorsement deals. Fast forwarding to today, content creators are now much more than just human ads. They get donations, micropayments, subscriptions, they sell merch, they sell online courses, and much, much more. This diversification of economic activities, as well as its popularity with audiences around the world, has rapidly professionalized the role of content creators, who can be considered economically as internet entrepreneurs engaged in the gig economy. As digital natives, children have a fundamental role in the production and consumption of content on the internet. Yet children and underage entrepreneurs who monetize their activity on social media are very often enabled, directed, and controlled by their parents, whose legal responsibility as a parent conflicts with the commercial mandate of a manager. Teen influencers have long been in the spotlight of mainstream media due to concerns about how they are the new child actors who are monetized and sometimes abused in the process by participants in the monetization supply chain, including parents. As entertainers, children have to work for content, which raises questions about time management, education, and general well-being, as well as legal issues such as child labor, privacy, advertising, to name a few. Understanding the state of affairs of child influencers is a very complex undertaking due to the fact that legal rules are currently heavily fragmented, but also that enforcement authorities tasked with the protection of children are at a loss for how to measure economic activities or visualize the commercial ecosystem that employs them. This is generally due to a lack of clear data to rely on, as we hinted at earlier on. Social media platforms have complex documentations for their free academic or commercial APIs, yet a lot of information that would make life easier for enforcement authorities is simply not retrievable under current data access infrastructures. Here's where we hope that the Digital Services Act will bring a much needed change. The Digital Services Act is a legislative proposal for a European regulation, which was proposed by the European Commission in December 2020. It is less than a month or perhaps a few months away from adoption when we will have the final text of the regulation. This is circa June 2022. It is part of a series of acts proposed by the Commission to deal with the regulation of technology in Europe, and it is also seen as one of the most comprehensive reforms regarding platform governance and intermediary liability in the past years in Europe and beyond. The DSA has a lot of intricate rules relating to platform transparency and verification mechanisms. Yet here, we'd like to draw your attention to a basic ingredient that is the secret to understanding how the DSA is expected to operate, which is the very definition of illegal content. According to the DSA, platforms are supposed to act against illegal content, which is defined in the draft Article 2 as any information or activity, including the sale of products or provision of services, which is not in compliance with union law or the law of a member state, irrespective of the precise subject matter or nature of that law. Although platforms are not under a general obligation to monitor their content, if illegal content is found by relevant national, judicial, or administrative authorities, platforms will have to act against that. Since the DSA mentions further European and national law, in our paper we discussed two specific examples which are directly relevant for child influencers. The Unfair Commercial Practices Directive as the regime applicable to the disclosure of advertising done in such content to protect audiences, which are often also likely child audiences, as well as the labor law regime adopted in France for child influencers by reforming the labor code to prevent child labor. In addition to those two discussions, framing consumer protection and labor protection questions, there's also media authorities. And for instance, in the Netherlands, media authorities recently adopted a new framework that pertains to a different type of European regulation, the Audiovisual Media Services Directive, which will also impact the activity of child influencers who might have to register under specific circumstances with these authorities. You can see here in this menu what exact circumstances those are. These are three examples that show very clearly how consumer, labor, and media law can be sources of content regulation, which can be used to interpret the DSA's notion of illegal content. The result is a complex web of rules and enforcement mechanisms at both European and national level, including legislators, but also agencies tasked with the application of these rules. All these authorities are particularly interested in legal digital enforcement, which our paper interprets broadly to mean the application of legal rules in practice. Generally, digital enforcement has been referred to alongside two narratives. One relating to the idea of making sure that rules of conduct that apply offline also apply the same way online, but also another one recognizing that there may be a difference between the policing of online versus offline activities. In the context of child influencers, leaving aside the legal uncertainty of the fragmented legal framework, or the vagueness of some of the legal provisions we might have referred to earlier or in the paper, one particular area of interest emerges, namely making computational tasks out of legal questions for the purpose of digital enforcement. This is exactly why we propose the idea of a legal compliance API, to simplify digital investigations and enforcement by national and supranational authorities in the European Union. We consider that this can be done by using social media platform data infrastructures and developing enforcement data structures. Our proposal aligns with a general trend that is sweeping across authorities at a considerable speed, namely that increasing digitalization of law enforcement is currently seen in a wide variety of regulatory sectors. The Legal Compliance API would reflect queries which can help authorities retrieve information for investigations, but at the same time, it would also require very specific registration standards for commercial actors to be able to be seen in that particular social media API. For instance, social media platforms should have specific labels for declared or non-declared content monetization accounts to facilitate triangulation with, for instance, the national registries of child influencers according to French law. Our position paper shapes this idea with a few necessary caveats, out of which I will mention 3 particularly important points. Content creators as internet entrepreneurs are third parties that social media platforms might align on together with digital enforcement agencies in terms of brand, but also advertising safe spaces. For this topic, platforms may very well have an incentive to collaborate with authorities. However, if investigations deal with systemic risks, as we have seen, for instance, in the situation of the Federal Trade Commission settling with Google with respect to child privacy on YouTube, platforms will not have the same incentive. Furthermore, the way in which data standards should look like and what role authority coordination should play in the development of a legal compliance API are questions that need to be shaped together with lawmakers and enforcers. Lastly, from an ethical perspective, this solution ought not to raise more issues than it solves. Public administration transparency and accountability mechanisms around the use of a legal compliance API are a must. And this is an ongoing conversation with technology used in governance in general. Our position paper does not aim to solve all of these issues at once, but rather propose this novel concept in a very particular context of user vulnerability. We welcome your feedback as well as your engagement in the hope that we can take this discussion further and develop informed approaches for the application of the DSA. Thank you.